Family Division sitting at 311 Jarvis Street here in Toronto. He was in private practice until 1976 when he was appointed to the provincial court. He's been a panelist and speaker at many continuing legal education programs on a variety of family law subjects, and we're very fortunate to have Judge Nasmith here today. Thank you. To my right, we have Paul Slan. He's a partner at Epstein Cole in Toronto. His practice is primarily restricted to family law. He's currently the Vice Chairman of the Family Law Section Executive of the Canadian Bar Association, Ontario. He's active in the continuing legal education area. He teaches at the Bar Admission course, and he's been a panelist and speaker at many continuing legal education programs. To my immediate left, again, you've already met Tom Wright, the Senior Solicitor Support and Custody Enforcement Branch. I like to call him Mr. Enforcer. In the materials, you'll note that the paper prepared by Paul and by me, we've entitled it Issues and Potential Problems. Now, our objective was to look at the enforcement process under the new Act and highlight some of the issues and potential problems that may arise. Now, we have done this in a chronological fashion in that we have first focused on the initial stage, that is, when the order is made. And our first question deals with the type of provisions that may be filed for enforcement under the Act. We continue on with the form of the support order, who may file an order, and so on, through to the default hearing and the status of an enforcement order itself. This afternoon, we're not going to deal with every question that we've raised in the paper. We're going to focus on perhaps the more provocative ones and the ones that haven't been dealt with already. We would ask you to hold your questions until the end of this panel, and there is time allotted for questions from you, but we'd prefer to do that at the end of the panel. So without further explanation, we'll begin, and I'd like to start by asking Paul Slan a question. And Paul, with respect to Section 1, Sub L of the Act, if an agreement or order does not state that the designation of a spouse as beneficiary of a life insurance policy is irrevocable, is that provision then a support order within the meaning of this new Act?
No, it wouldn't be a support order, and this question brings out the point that aside from the ordinary type of support order, as a lawyer, when seeking an order, you must, if you want it to be enforced, specifically look to the definition section in SCOE of support order, because you may be surprised at what you find there. If a life insurance provision contained a designation, but it was not irrevocable, then it wouldn't strictly fall within the definition of the support order, and therefore it would not be capable of enforcement. Now, for that reason, it's important to look at the definitions, and in that type of situation, you would have to provide that there was an irrevocable designation.
Tom, how will the director monitor this irrevocable designation, and what steps could the director take if an order provided that the designation be irrevocable and the debtor subsequently changes this designation?
The first issue arises as to when the order itself arrives in the office. If, as Paul has indicated, the provision does contain the words irrevocable, then it does fall within the definition of support order. As a result of that, if it's clearly stated, the director then may write to the insurance company for purposes of confirming the existence of the policy. I hearken back, as an aside, to my private practice days, and I don't know how you feel, but this used to be one of the areas that I had a great deal of trouble with in terms of determining exactly where the responsibility lay in terms of from year to year, and making sure the policy is in place, and what happens if I don't know about it. And there are certain practicalities that make it very difficult. Insurance companies may well take the position that we're not required to give you any information at all. You are not the policy holder, and as a result, you have no entitlement whatsoever to any information about the policy. And in fact, that has taken place in certain instances, which makes the monitoring extremely difficult. It may well be that the practice will have to develop that some mechanism is included in the order itself, similar to what you see in agreements, whereby the party who is to maintain the policy is required to provide evidence of proof of payment or something like this. If this type of clause, which does not commonly, for some reason, appear in orders, could be put into an order, that may well provide some sort of an answer as far as how this type of monitoring could take place.
Paul, then maybe what I can ask you, what did lawyers do before the new act came into force to ensure that the designation was irrevocable and maintained that way?
Well, as Tom points out, it was a pretty standard practice to include a monitoring provision in a separation agreement, which would provide that evidence that the policy was in good standing would be produced on an annual basis, and evidence of the beneficiary designation. But it was rare, in my experience, for that to be put into an order, and it may now be that we want to include those provisions in orders as well as in agreements.
Now, Tom, you alluded to this in your question. Has the Director's Office, in fact, written to any insurance companies at this point?
Yes, we have. And as I say, the difficulty that we have encountered to some extent is the lack of any type of consistency with insurance companies. Some, I think quite properly, are saying the policy does not belong to the person who's been designated as the beneficiary, and they feel, as insurance companies, that they have a duty of confidentiality to their policy holder, and as a result may well refuse to provide that type of information, which makes it very difficult and perhaps impractical in terms of being able to get that type of information.
Okay. Again, dealing with provisions in an order that are enforceable under the Act, I'll direct the next question to Judge Nasmith. Judge Nasmith, is an order for costs enforceable under the Act?
That seems to be... Right?
Terribly sorry, that's an urgent family matter.
I have an urgent call.
Okay.
I'm not trying to get out of the question.
Yes, we'll grant you an adjournment, Your Honor.
Let's come back.
Pardon?
Come back.
Yeah.
There's a Ricky Harris who's wanted on the phone on an urgent family matter.
I'm sorry, I thought it was...
Who is that, Judge Nasmith?
Ricky Harris?
Ricky Harris?
Oh, could you do that? Thank you.
Thank you. Judge Nasmith. This is fun.
I think I'm relieved. That seems to be one of the early questions. The definition of support orders is fairly broad. It's in Section 1, and Section 1N of the Act deals with legal fees. And there's a very thorough and compelling decision, reported decision, referred to in your materials, called Newsom and Maxwell, in which Judge Bean of the Provincial Court takes what I think he calls himself a literal interpretation of the definition section and finds that costs are not included as support orders for the purposes of enforcement, which would presumably include costs awarded at the time of the original order for support and costs of the enforcement proceedings themselves. That decision is under appeal, and I guess the important thing is to find out in the next few days, I gather it's due next month actually, what the result of that appeal is, because that may be fairly important if there's a clear appeal decision on whether or not that literal or strict interpretation of the wording is to be applied, or whether a more liberal wording is applied, such as in the case of Alter, which Judge Bean actually deals with in his decision in Newsom and Maxwell. That's a case where Judge James had a similar situation interpreting the Reciprocal Enforcement of Maintenance Orders Act, which also has a definition of maintenance, which uses the same format, that is, includes and then a list, which I like to refer to as a non-exhaustive list of things that are included in cost. Now, if you look at the things that are included in the definition of costs in SCOE, you'll see there are some, it's very wide. So I suppose the other argument, to take the other side of Judge Bean's case, one would argue that it is a non-exhaustive list, and one could take the same approach that Judge James took in the Alter case and hold that, in fact, one can either add on the idea of costs being part of the support order, or one can ignore the rather, I guess I'd have to say it's rather poor drafting. If the legislature intended that legal fees meant costs awarded in court, it wasn't probably the best of drafting. And I think Judge Bean hints that his idea is that the legislature did not intend to include costs. At first blush, my reaction is I would be rather inclined to the view that they probably did intend to include costs, but they didn't express it very well. So if the Dewsum and Maxwell case is overturned, that will probably be an important case to know about. If it isn't, and there are no quick amendments to the legislation, I suppose it remains a very pressing problem for those who have significant cost awards to try to have enforced through SCOE as well.
Judge Nasmith, I believe that the Honorable Judge Mendes da Costa of the Unified Family Court rendered a decision in Allen and Morrison, and that was under Section 27.1 of the Family Law Reform Act. And I believe that case stood for the proposition that costs can be enforced if they're attributable to support. So that was his opinion.
Yeah.
Now, if that is correct, what could a lawyer do to ensure that costs are attributable to support?
Well, that's a good case to mention, because if you get over that hurdle as to whether or not cost is included in the definition Section 1N or Section 1 at all, then quite apart from that is the problem of whether or not there's any practical way to enforce costs. And you heard Linda Feldman earlier say, as a matter of policy, the director isn't interested in lump sum awards that don't apportion the support itself between the dependents. Well, there's a similar problem with regard to costs, and the Honorable Mendes da Costa refers to that in the Allen and Morrison case and says that costs are part of the order, the support order. Of course, that was before SCOE, and Judge Bean again distinguishes that case because it was before SCOE. That the only way you could add costs on as part of the support order is if the judgment is such that it apportions the costs as between the various issues, for example, in the divorce action. So there may have been a divorce and a custody issue and a property issue and a support issue, and of course we all know it hasn't been common practice to ask the divorce court judge to break down the costs as between the various issues, and it may be now that a lawyer will be well advised to read Allen and Morrison, to consider Dewsum and Maxwell and the results of the appeal, and then to maybe be asking judges to break down the costs as between the issues that are before the court and when the original support order is made, so that the part of the cost attributable to the support award will be clearly enforceable.
Thank you. We heard Elisabeth Sachs and Michael Marra discuss custody, and I'd like to ask Tom Wright about the situation of joint custody. Would an order for joint custody be enforceable under the Act?
The real issue here is related to the existence of joint custody, and a point that was touched on, that what we're seeing today to some extent are orders that are styled as joint custody, but in fact to some extent it is an attempt to make both parents happy with the result being that physical care and control actually vests with one parent. And I think that it's important that in terms of enforcing joint custody, that whether or not that clause appears in the order. The other situation, of course, is what I would consider to be the true joint custody arrangement, and more like shared parenting, when in fact a child will spend a period of time, be it a month, a week, or whatever, with one parent, and in fact will then physically relocate, because it's usually the child as opposed to the parent that is doing the moving, would physically relocate to the residence of the other parent. That, to my mind, is a true joint custody situation. That presents a significant difficulty as far as the director would be concerned, as far in terms of the legislation, who has custody, the possibilities of having to enforce for both parties at different times. It's such that it would have to be looked at almost on an individual case basis. So I can't give an answer that would say yes or no. What I can draw, though, is the distinction between the physical care and control issue that Michael touched on in his presentation and this other area where the child is, in fact, under the physical care and control of a different parent at a different time.
It seems to me, though, if the parties themselves are fighting over the joint custody, then one or the other of them is going to apply for a variation for sole custody in any event.
I would assume that's exactly what would happen, which would seem to me to be appropriate, because joint custody certainly has a certain meaning, one of them being cooperation.
Judge Nasmith, maybe I can ask you if you see any particular problems with respect to enforcement of joint custody orders by the Director's Office.
Sure I do. At first blush, I see some problems. I think Ms. Sachs, or one of the speakers earlier, referred to the problem with the definitions. And if you look at Section 37.2 of the Children's Law Reform Act, which is the section under which you apply for an apprehension, for example, the person who can apply under that section is the person, quote, entitled to custody. And I can see a lot of fuzziness about who's entitled to custody in a joint custody situation. What you may really be saying is, I'm entitled to my turn at residence now, or something. There's a bad fit there, I think.
Right.
And Ms. Sachs referred to that. I agree with her comments.
Judge Nasmith, another question for you. What about, and this has been touched on, the support and custody provisions of an order made under the Divorce Act? Clearly, those can be enforced by the Director, and maybe you could just expand upon why that is the case.
Well, I don't see any problem there at all. There are a lot of reasons. Many of them are covered in the material. The definition seems to be wide enough, and I think the Act is clearly designed to include all orders enforceable in Ontario, regardless of the court level. If you have any doubt about the extent of the definition in SCOE itself, then there's a good case cited here, a decision of Judge Steinberg, in which he goes through some of the common law as to why a province would be able to pass legislation that would enable the province, as an administrative matter, to enforce orders regardless of which court they may emanate from. I think the material set that out very well. There is a lingering kind of issue, though, and that is that was touched on by one of the speakers earlier, and that has to do with the old, if you remember the old BC reference case, the Polglaze case, where the Family Law Reform Act and a similar act in British Columbia provided that the provincial court had jurisdiction to grant exclusive possession. And then there was that case, which was essentially a test of the old Section 96 dichotomy, and whether or not this business of dealing with property was business that had to be done by judges appointed under Section 96, that is, federal judges, and the decision went against the legislation, and from that time on, Ontario has towed the line, and now in the Family Law Act, the provincial court is excluded from granting exclusive possession. Question, when those orders come in, say, from the divorce court, the decrees are filed for enforcement, what's going to happen when it comes to enforcement things that are done in the provincial court that are listed as things that can be done under SCOE? Will there be a similar attack on the legislation itself as another attempt to work Section 96 matters into the hands of provincial court judges who are not Section 96 judges? I can see the potential there for another one of those challenges. Although we're one step further removed, we're not making orders about exclusive possession, but we're being asked to enforce orders of exclusive possession and make other orders consequentially. To me, that's the only issue. I think we're very well covered in terms of having jurisdiction to enforce support orders from all courts. And the tradition, also, the history is that that's what we have done. There's no change in that regard. We have, in the provincial court, been enforcing support orders from the Supreme Courts, for decrees nisi, and Supreme Courts out of the province as well.
But it is interesting to note that the drafters in the Attorney General's office sometimes don't seem to talk to one another when they're doing different pieces of legislation, because Bill 60, which is the access enforcement bill, contains a specific prohibition that it does not apply to access orders made under the Divorce Act. So one naturally would ask, why does it apply to a custody order made under the Divorce Act? Why would SCOE apply, but Bill 60, the access enforcement bill, not apply concerning access? It just doesn't make any sense at all. And it seems that the drafter of Bill 60 was concerned about the constitutional problem that Judge Nasmith raises. So someone in the ministry is concerned about it.
We'll move on to the next stage, dealing with who may file a support or custody order. And this already has been touched on, but maybe it bears repeating that under Section 3.1 of the Act, a person entitled to support or custody under the order, or a parent of a child entitled to support under the order, may actually file it for enforcement. So it appears that a debtor, if a parent of a child entitled to support under an order, may file the order. And maybe I could ask you, Tom, if the debtor can file a support or custody order, can he or she also withdraw it?
The Act would appear to permit that. And what we mentioned earlier was that when anything is done by way of either filing or withdrawing, a notice is sent by the director's office to each of the parties confirming what has taken place. And as a result of that, if the withdrawal by the debtor created a particular difficulty for the creditor, that person would have notice and have the right to come back and file that order. So it may create a temporary gap, but it's certainly not a problem. It doesn't have basically a very simple answer.
Paul, and again, it may have been touched on, but bears repeating. How and when can the order be withdrawn from the director's office?
Well, I think it was mentioned earlier that Section 4.1 provides that if a written notice is signed by the person who filed the order or on whose behalf it was filed, is filed with the director, then the order is withdrawn. I'm just wondering what the words "on whose behalf it was filed" mean. Does that mean a child can go down to the director's office with a signed notice, because that would be the person on whose behalf the order was filed, and have the order withdrawn? Because certainly the payor spouse, perhaps on the access visit, may be getting the child to sign the notice and make sure they go down on Monday to withdraw the order.
Perhaps if I can add, in terms of another possibility as far as on whose behalf it was filed, there is another provision in the legislation which deals with the automatic filing. And in that case, it's the clerk or the registrar who files the order. And I suggest that perhaps the words "or on whose behalf it was filed" would in fact refer to the person whose order was filed by the clerk or registrar, as opposed to that person directly. I think that's another possible interpretation.
Judge Nasmith?
Just while we're on this tricky business of how you withdraw, one of the problems that's arisen already is people come into court already decided on a consent order that they don't want the order filed for enforcement, and they have that rather interesting provision that says that every order shall contain a provision that it's to be paid through the director, and they say, "Oh, no, you don't understand, we're going to not be paying through the director." And they're into that sort of round the mulberry bush thing where they have to put the term in the order, then the order is signed, then it's filed with the director, and then the notice that they don't want it filed with the director is filed. Now, at that point, it's actually a withdrawal. But under Section 3, as I understand it, and I've just been corrected on this by my discussions with Paul when we were talking about this panel, I think that although the administrator at our court is married now to the idea that that's the way it has to go, I think that Paul was right when he suggested to me and to the others that you should be able to avoid that clause in the order, and you should be able to never be in a position where you have to withdraw, that is, stay out of it in the first place, if you've sent a notice to the director's office before you come in to get your consent order. Because Section 3 concludes with a phrase that applies to the whole of A and B, and says, unless the person who instituted the proceedings files with the court and the director's office a written notice, etc., that she does not wish to have the order enforced. And that's different from withdrawing. That language suggests avoiding the thing in the first place. The tricky part being that you'd have to actually have, I don't know what you'd have in your hands, maybe a copy of a letter or something, showing that you've already notified the director that you do not wish to have the order enforced through SCOE.
I think that we may have a divergence of opinion on this issue on the panel, and maybe it would be of assistance if Paul could explain in more detail his reading of the section of the Act.
I don't think it bears taking too much time. Section 3, sub 3 says that it's qualified by the words, unless the person who instituted the proceeding files a written notice saying that they don't wish to have the order enforced. Now then you go to section 4.1, which says that it can be withdrawn at any time by the person who filed it or on whose behalf it was filed. There would be no reason to have both sections unless section 3.3 was designed to avoid the process right from the outset. Otherwise, it would simply be a duplication of the process.
Okay. Now, I know that, Tom, your reading of the section is that the wording has to be included.
That's correct.
Right. I'll put you on the spot. Tom, is there any policy reason for having that wording included in every order?
I think one of the things, and certainly I can sit here and say with some feeling of relief, I suppose, that I wasn't one of the drafters of the legislation, so I certainly do not pretend to speak for whoever it was that put the legislation together. It's always one of the difficulties in terms of reading it. Lawyers obviously are notorious for being able to read things in any number of ways, and as has been indicated, we do have a divergence of opinion. I would suspect that one of the things in looking at the section and what it was designed to do or what it should be designed to do would be the purpose of filing with the director, excuse me, with the director at all if the order is never going to arrive in the director's office. Seems to be basically a worthless exercise when in fact the order is never going to get there. What possible reason would there be to have that requirement in the section if the director would never even know about the existence of the order? Secondly, and I think another feature perhaps from an enforcement standpoint to consider is that it's all well and good that at the time the order is first made that the words don't appear. And as long as the order goes along and the monies flow, and that's just fine, no one's going to require enforcement. The problem comes when reality sets in, and you've heard some of the figures today in terms of percentages, and the payments are not made, then the benefit of the clause, which clearly states that it shall be paid to the director and enforced by the director, does not appear in the order itself. It's implied by statute, by the fact it's filed. I think it makes it clearer and neater for all concerned, quite frankly. And I think the real concern from lawyers, certainly from a creditor's point of view, is what am I going to be able to do at this time? Very simply, it's a paragraph in an order that may well assist my client somewhere down the road. I think the reality of enforcement is such that you must consider the very large possibility that there may be default. And by not putting the paragraph in, if you create a problem for your former client, and it may well be a former client, then you really haven't done all you can by simply including the paragraph.
But sure, that's a matter for your client to decide.
Indeed.
But then again, I suppose if we all decided, well, you know, at the outset when the order is issued and entered, we're simply going to file these notices and the wording will never be included, that we could have a lot of orders that don't have that wording instead of doing what the Act said would be preferable, which is to have the wording. And so people are aware of the director's office and the function.
Exactly, and certainly the right to withdraw, as we say, for parties that don't wish the director's office to be involved is clearly set out elsewhere in the legislation. They can do that at any time if they choose to agree. And there's nothing that prohibits them. The fact that it is filed in the office originally doesn't mean it can't come out at a later date.
Okay. So let's move on to possible issues once the order has been filed and we're into the enforcement stage. Tom, I'll ask you again, although you have mentioned, and it's been mentioned quite clearly, that the director's position is that he or she is a party to the proceeding and not a counsel, not acting as solicitor to the creditor. Okay. Maybe I can ask you then, will the director take instructions from the creditor with respect to the proceeding, and particularly the various methods of enforcement?
At this point in time, I think everyone was mentioned earlier, we're 4 months old, and in looking at how we do things and what's best and what works best, we've made it known and are attempting to make it known that we're open to suggestions, some of which we have had many. We look at them, and if we feel that things should be incorporated to improve how we're operating, that's what's being done. We have looked at other jurisdictions in Canada that are operating with an enforcement program, notably Manitoba and Alberta. Alberta, with respect to this issue of taking instructions, has very clearly indicated that you're not, if you want to enforce properly, and as someone mentioned earlier, with a fair volume, that there's a strong problem with taking instructions on an individual basis. It becomes more of a true solicitor-client arrangement, which has been indicated is not what the director's office provides. It doesn't provide that type of service. So in terms of taking instructions on doing something specific, the concern that exists as expressed to us by Alberta is that if you were to say to a creditor, for example, we're about to seize or garnish a bank account, inadvertently that creditor in the unfortunate situation may well advise the other party that sort of action is underway. We're told by Alberta that in fact that's what happens. You know, call up and say, oh, by the way, how are you going to get to work tomorrow? The director's going to come out and seize your car. Well, that's all very nice, and certainly it gives the creditor in the particular situation some satisfaction. Unfortunately, that's not what we're trying to do. We're out there to enforce the order, to collect the arrears that are owing, and if that's what happens, then it basically creates a very large difficulty, and in fact, probably impairs the neutrality that we do in fact encourage, and gets back to this directness between the parties. And in this fashion, if we do in fact look at the enforcement action and decide what's to be taken by way of action, this takes the thrust away from the creditor. It's not the creditor. It's an interesting question, but it's really not the creditor who's saying, do this, do that. It's more a matter that the creditor is now in a position potentially that if something is done and the debtor is unhappy, that the creditor can say it's the director. It's the director that did this. It's not me. They look after this for me. And that direct antagonism that could exist and flow over simply will not happen.
Tom, what might happen if you did have a creditor who said do this, do that, was a very difficult, uncooperative creditor? What might the director do?
Well, one thing the director can't do by statute, we have no right to withdraw someone.
You could send the file to Heather Robertson.
Heather might like it. Outside of having Heather's cards circulated throughout the province.
Oh, that's even better.
What we would have to do is, I think it's clear that if there is a disagreement, there is discretion in the legislation as far as the practicality and the manner in which the enforcement takes place. And quite frankly, at that stage, if we can't do the sorts of things that we're being told to do, and we feel that there's justification for that type of thing, and it's been mentioned again, the director's office is not a hammer. It's not a hammer to be used by creditors. And I think we take great care in ensuring that we're not looked upon in that light. We have a very clear duty. We have a duty to enforce orders. We'll do so, but we are, to a large extent, cognizant of the position that we are in, and basically look at all facts before we decide. I can't answer the question specifically Gretchen, because it hasn't arisen at this point in time. I suspect that that person on their own would probably decide to withdraw.
Right. Judge Nasmith, what's your opinion on this issue? Is the director a party or counsel?
Well, I guess the legislature is trying to get the message across fairly clearly that they are a party. Not only that they're a party, but they're completely in the shoes of the creditor, so that they displace the creditor. And while they're operative, the creditor virtually doesn't exist, certainly from the point of view of support. I've heard some moderating statements with regard to custody and the intentions and the policy of the office with regard to custody, but is this the chance for my little philosophical speech? No?
Yes, it is.
You know, there was some talk about why this government agency has been brought into existence at all, this enforcement agency, and there have been different comments about the gap that needs to be filled. And in the 11 years I've been in this job, I've heard various theories about how lawyers just weren't interested in following up on divorce decrees and so on, and I've heard the theory, well, it's not really the lawyers not interested, it's the clients, the creditor clients don't have the money to hire lawyers to pursue the remedies that are available, and most of these remedies have always been available. And then there's the other theory that, you know, legal aid should have covered it, and they didn't. In any case, there was a gap. And then there was the theory that we kept hearing in sort of academic ways, that we weren't meeting our expectations as judges. I think there was an old philosophy that the magistrates' court, which took over the deserted wives' summonses, you know, were supposed to more or less police the whole thing. And what's happened gradually is lawyers and judges have come to the point of view, maybe by evolution, as more lawyers were in the court and more legally trained people were appointed to the bench, that there's an anomaly, a conceptual problem in having a court and even a judge play the role of someone vigorously is the word that you people use, vigorously pursuing one of the parties on behalf of the other party in selecting remedies on their behalf and so on. And I think gradually this message got across that the new world didn't allow for that kind of a perverted role on the part of the judge. So in that sense, the creation of this office is sort of a relief and sort of a final burying of the idea that the court can do the enforcing decisions themselves and elect remedies and so on. Now we have a whole new set of conceptual problems, in my opinion, and subject, of course, to being able to change my mind if any of these issues arise and I hear learned counsel arguing them. I can see a lot of problems with this concept of a director who, according to the policy, takes no instructions, therefore clearly is not in a solicitor and client relationship, and these things have been confirmed earlier today, is not interested in variation applications, and we'll do a quick exit when that comes up, is not interested in negotiation, forgiving arrears or anything. So, as one of the earlier speakers says, that's not the way these things usually work. You know, in my experience, as I say, 11 years, there's a vast majority of the cases where these things aren't so clear-cut as that, and where there are variation issues that almost inevitably arise when enforcement gets hot. And I can see a problem with lawyers who, say, acted for clients in a divorce action, and Ms. Robertson touched on this, really having a dilemma as to what to tell their clients about getting into this thing. Because, you know, there's some fairly devastating things that can happen at the election of the director, which would profoundly concern some families. You know, the whole thing is set up, and I heard Tom say something just a moment ago about, well, we don't want the guy to blame the gal. You know, she can say, I didn't put you in jail, the director did, sort of thing. Now, I can understand that, but there's that very patronizing sort of flavor to that, as if all of the creditors are kind of helpless souls, and all the debtors are kind of no good runaway types. And that probably quite fairly describes a certain number a certain number of the cases. But we all know that, and we've all had clients who fit into a little more generous category than that, and more civilized than that, who are going to want to have some control over these things, some control over whether the guy's wages get garnished, or whether the police are coming in on an apprehension, or whether there's imprisonment being threatened, and so on. So that total lack of control, and I think one of the speakers used that term, I think it's really going to be a problem. And the lawyers who are acting for people when they're getting these orders are going to have that dilemma of whether or not to turn this system loose, which is a system which now is announcing itself as being clearly without instructions from anybody, to create those kinds of problems in situations where it will be problems. So that we have the danger of something being done that nobody really wants done, and that may be damaging to the whole bunch, the whole family. That we have the danger of, we have the confusion about the dance in and out and in and out. You know, I'm here for the enforcement, but I'm not here for the variation, so I need my lawyer back again for the variation. And that kind of an in-out dance, I think, is going to be confusing to the courts. Maybe it won't be, but I think that there's a new conceptual problem, which is this patronizing kind of position where you don't take instructions. And there's a certain, I've heard people say, gee, it's going to be so inhuman, it's going to be so detached. And while there's that one argument, there are certain cases where it may be an advantage to be detached. I can see a lot of cases where it could be a serious disadvantage to be so detached and so out of control of what's happening. So unless the director's office sort of evolves into something a little more directly responsive to the wishes of the creditor client, the creditor non-client, and the creditor's lawyer, I think the lawyers are going to have to be able to get along with the director's office. They're going to be a team, you know. They're going to inevitably be a team in this effort, rather than, and we heard that kind of stuff coming from Mr. Marra and Ms. Sachs concerning custody. I think that's probably the way, I would predict that's the way support will evolve as well, except in those cases where paternalism really is justified, you know, where paternalism really is necessary. No, that's my philosophical.
Well, that's very interesting, Judge Nasmith, and it is. Obviously, there's some advantages and disadvantages, and I think that the concerns that you've raised are very important ones for all of us to consider. I just wonder if Tom would like to say anything in response to that.
Not in response, but certainly in acknowledgement of the nature of the problems that Judge Nasmith has identified. He used the word evolve, and I suspect that he's quite correct, that, as I mentioned, I don't mean to beat it to death, but we are only 4 months old, and we will have to flesh out just exactly how we're going to operate. And as far as being the director not being interested in doing certain things, I think there's a distinction between interested and able. And certainly as far as the legislation is concerned, there's nothing in the legislation that allows the director to participate in variations. The issue is clearly limited as far as the statutory duty to enforcement. There are cases, and it's the only guidance that I can use in looking at what enforcement means, that state very clearly, and I think it makes good sense, that enforcement is not variation. It may be that as matters progress that legislative amendments or otherwise will be looked at, but at this point in time it's not so much a matter of being not interested. There really isn't a lack of interest. There's simply a matter of fulfilling the statutory duty that exists at this time.
Okay, well, let's...
May I say, I agree, there are many advantages. Clerical and tracing and so on, that obviously everyone can benefit from.
Particularly with respect to custody, I found Michael's comments about the various sources of information that will be available. I mean, clearly that's going to be a tremendous time saver and of tremendous assistance for lawyers and clients. Maybe if we can move along to a completely new area, and that is the role of the creditor's lawyer. Now, again, Heather Robertson really touched on this and alluded to the importance of lawyers acting for creditors to assist them in preparing the filing package and making sure that it gets to the director's office. So maybe we can consider more specifically a little bit about this Section 10 charge that was also referred to. And Paul, I'd like to ask you whether a creditor's lawyer, if a creditor's lawyer can register a support order in the land registry office against the land of the debtor pursuant to this section, even though the order has been filed with the director's office.
Well, it depends on whether that's interpreted to be enforcement of the order or not, because Section 5 of SCOE says that no person other than the director shall enforce an order. So it seems to me that if there are arrears under the order, then and the order has been filed, then that is enforcement by the director, and the creditor's lawyer is not, or the creditor is not at liberty to file the Section 10 charge against property. However, Section 10 doesn't say that there has to be arrears under the orders, so if there were no arrears, it seems to me that it would be open to the creditor to register the charge at any time, because that would not be enforcement. That would simply be a precautionary measure, and something that all creditors' lawyers should consider very carefully when advising their clients, because it's a very simple procedure to register the charge against the property, and that will protect the creditor in the future in the event that arrears do arise.
Okay, so what would you do if you're a lawyer, if there is an order registered, the order is also filed, and so that's enforcement, but you have to do something really quickly for the client because you know that, say, the debtor husband owns a property and is refinancing. What would you do?
I'd probably withdraw the order and do it myself if I had to do it really quickly, unless I could be assured that the director could do it as quickly as I could.
Okay, why don't we move on then to the access to information, and again, this has been touched on, but maybe, Tom, I can just ask you to just, again, take us quickly through the various sources of information that the director will be using to locate the debtor.
Well, as Gail has mentioned initially, with respect to computer links, we do have access to MTC records with respect to motor vehicle registration as well as driver's license registration. Again, it's also, I think, as an introduction to this whole area, it's important to note that the sections really, the Section 6, which what we're talking about, really only addresses the three types of information I referred to initially. The other source of information which we haven't ignored is the creditor. And certainly the creditor is an excellent source of information in a lot of cases. And that person, of course, is then contacted. The filing package that you have seen is in fact completed by the creditor, and we do look at that package to see what types of leads, or however we should describe them, have been provided by the creditor. PPSA searches are another excellent source of information with respect to not only assets but addresses. Bell Canada Directory Assistance, contacting friends, family, bank, present employer, past employer, landlords, municipal tax office, credit card companies. Again, the type of situation that you're in will dictate to a large extent where you look to for information. The Vernon's and Mite's city directories, which are available, I think, in most reference libraries, we also use. They're an excellent source of information. And in fact, court records, if the need arises, they are in fact public, accessible by the public as well as the director, of course. And in fact, we would use that source as well. That's basically the sorts of things we look at.
Okay, Paul, we've heard about the federal legislation, the Family Orders and Agreements Enforcement Assistance Act. Will that permit access to additional sources of information?
If it's ever proclaimed, it will. They promised that it would be proclaimed in July of '87. It has not yet been proclaimed, but if it is proclaimed, it will allow access to the Department of National Health and Welfare data banks and the Canada Employment and Immigration information. So it will be helpful if it comes into effect.
Okay, now again, Paul, Tom mentioned earlier that this Section 6 sub 6 of the Act with respect to access to information essentially means that the director could ask a lawyer for information with respect to a debtor address and so on. And what would you do as a lawyer?
I agree with what Elisabeth Sachs said earlier. I certainly would not be anxious to provide that information and would probably force the director to bring a motion. Then I'd be running the risk of the cost exposure, which is mandatory. The only argument I've been able to come up with is I took a look at the Child and Family Services Act, because it has a similar reporting provision with respect to child abuse. Now, that's section 68 sub 7 of the Child and Family Services Act. That section specifically uses the word privilege. This section in SCOE doesn't use the word privilege. It just says common law rule of confidentiality. Also, the Child and Family Services Act seems to contain a section that gives a lawyer immunity from suit by his client if he does report, whereas there is no such section in SCOE. So there may be some arguments to be made that this means something other than what the section in the Child and Family Services Act means, but certainly open for argument. I wouldn't be anxious to offer the information if asked.
Now, Judge Nasmith, without asking you what exactly you would do, if such a motion were brought before you, maybe I can ask you if you have any comments to make in general about this section.
It's very interesting. I suppose that it appears to be wide enough when it says the court may order any person to provide any information. At first blush, it appears wide enough to cover a lawyer giving the address of his client. And the issue, the question, the outstanding question, obviously, is whether or not there's still a solicitor-client privilege operating there, or whether somehow Section 6 sub 6, which says despite any common law rule of confidentiality, completely disposes of the possible solicitor-client privilege. I would have some doubts about whether it did dispose of the issue of solicitor-client privilege. Paul makes a good argument I've never heard until this moment about the Child and Family Services Act, which carefully uses the words confidentiality and privilege as if they are mutually exclusive. Now, it's a different act, but it's interesting. I guess they may have intended by confidentiality to include solicitor and client privilege. I would have thought, just off the top of my head, that there's a common law discretion in the judge to recognize privilege. And I don't think that common law discretion in the judge to recognize privilege is abrogated by Section 6.6. So my first reaction would be there'd still be a discretion, even if 6.6 is taken as covering solicitor-client privilege. It says the judge may. It says the court may order, despite common law of confidentiality. So that doesn't mean the court must order, although speaking of what the court must do, that's a very interesting provision that the court must order costs against the solicitor. That strikes me as a very unique legislative approach to something that is, to my knowledge, always been a matter in the judge's discretion. Under the Courts of Justice Act, it still is the matter of cost generally is a matter for the judge's discretion. So the legislature appears to be taking the judge's discretion away on the issue of cost, which is, as I say, very interesting. I like Ms. Sachs' solution. I suppose there will be some judges in some cases who will be very attracted to her solution of $1 costs if they feel it's a case there shouldn't be costs and they feel that the legislature has bound them to order costs even if they think there shouldn't be costs. So you'll probably see a $1 or 1 cent order in those cases.
Well,
but anyway, it's all moot at this point.
After this program, we'll all be well armed with arguments to make on such a motion.
I think you're trying to protect me, but I'm afraid I might have to disqualify myself from some things. I'm very open to the other arguments, I must say.
Well, let's move on to another issue. Defenses. Paul, are there any defenses to a notice of garnishment?
Oh, yes. The rules of the provincial court provide that a dispute can be filed, and then the court, normally the dispute will say that there's no money owing, or that there are no arrears, and the court is to hold a garnishment hearing in a summary manner. I think it was pointed out to me that the amended rules of the provincial court provide that even if a dispute is filed, that doesn't stop the garnishment, so that the garnishment will continue, the monies will still be taken off the debtor's pay or whatever is being garnished until such time as the hearing has been resolved one way or the other. It is open, I suppose, for a debtor to apply to the provincial court by way of motion to ask for a stay of the garnishment pending the garnishment hearing, and the judge could resolve it as he saw fit.
Okay. We've dealt with creditors in Section 10 charges. Paul, maybe you could tell us, how can a debtor have a Section 10 charge removed from title to property?
Well, if the property was being sold, it wouldn't be a problem, but if they wanted to put another mortgage on or somehow refinance the property, the debtor would have to ask the creditor to remove it. The creditor is under no obligation to remove the charge because, again, there does not have to be arrears in order to register the charge. So the creditor could sit back and say, I'm not going to remove it. At that point, the debtor would say, well, I'm not going to pay the pay the order, and they'd be into a fight. The other way is to apply to a judge of the provincial court, pursuant to Section 10 sub 3. The judge can make an order discharging that charge or postponing it.
Let's move along to the default hearing. And Tom, what powers does the director have if use of these other enforcement mechanisms doesn't result in recovery?
In addition to the Section 10 charge and garnishment and, I suppose, seizure under a writ of seizure and sale, there is, of course, the ability to do an examination in the case where it is a Supreme or District Court order. The ability to do an examination does not yet exist with respect to family court orders. So what you have is, under Section 11, as I mentioned earlier, either the person who's filed with the director or an individual under Section 11.2 can apply for what we all know as a default hearing, since there are arrears of money owing under the support order. And the director would, in fact, and does in fact have the right to require that the debtor appear at the default hearing, the same as any other creditor basically has, and the matter would proceed in accordance with Section 11.6.
Now, Tom, I'm sorry, but you may have mentioned this, that the director can also require that the debtor file a financial statement and to appear. And what would happen if the debtor didn't do that?
Well, I think that the reality of financial statements, certainly in my experience, has been that you really don't see them until you actually attend at the default hearing. It's the unusual case, although it would be hoped it would happen more frequently, unusual case where the financial statement is earlier. So if you arrive at the default hearing, and as long as the debtor's there, obviously the financial statement can be provided at that time. If the person doesn't appear, the director can ask the court, the same as any other creditor could, to request that a warrant be issued for that person's arrest for failing to appear.
We've heard about the statement of arrears that will be prepared by the director and it's presumed to be correct. Judge Nasmith, would it be open to the debtor to challenge the accuracy of this statement?
Oh, I think absolutely, yes. It's a question really of what the effect of that presumption is in the dynamics of how the default hearing would go. Presently, I think the concept is that a debtor at a default hearing would be asked if there's any issue about the arrears. And if he said there was, then the present practice, I think, would throw the ball back into the creditor's court to say, okay, prove the arrears. One possibility is that presumption, if it's recognized as such, and someone can figure out exactly where it's supposed to plug in, would be that step would be crossed, so that if the debtor says, I dispute the arrears, then the creditor, who would normally have to get in the witness box and say, here's what the arrears are, wouldn't be there, and the director would be there and would file this statement of arrears, which would be presumed to be correct. I think the interesting question then would be, well, what does it take to rebut that presumption? So if that happens, then the debtor gets in the witness box and says that statement is under oath, that statement is completely wrong. That may be the end of the presumption. So it may be a very short, that's one possible result. That would be a very short-lived presumption. Now, if maybe Tom has some argument that it goes another step, that it goes farther, and
Tom?
that the creditor, in effect, would never have to show up at such a hearing, that the debtor would have the onus of, throughout, of proving that, in fact, he did make the payment, say. I'm not sure what the answer is, but that's the question.
I think that in a situation like that, where you have basically two contradictory pieces of evidence, then it really does come down to a matter of credibility. And I suspect that the court may well have to look at that issue of credibility in terms of is there any reason to believe one person or another, and is the test not, in a civil sense, balance of probabilities? And with respect, I would think that credibility then becomes the issue, and if an examination or cross-examination discloses information that would in some way impair that credibility, then I would suspect that the conclusion could be reached that that evidence was not to be accepted. I also think that there is some onus on a person who is saying, I paid, to in some fashion support that particular position. If not, then as I say, we're back to a credibility question.
Judge Nasmith, you may also be faced with a debtor who says, well, I want to vary the order. Could the debtor bring a motion to stay the enforcement proceeding under this new act?
I believe so, yes. There's no rule in the provincial court rules at the present time, although I suspect there may be shortly, that all the rules are being revised, and SCOE is not the least of the acts concerning which the rules are being revised. But there presently isn't a rule, but of course the rules of the family court have some provisions that provide where there is no rule, then the directions of the court are to apply and so on, and there are lots of chances to fill in the blanks. And I would say my first reaction is yes, of course there could be a motion to stay enforcement. The new enforcement rules with regard to garnishment, which have been passed and which the speaker referred to earlier, 75 to 93 or something. Rule 86B, for example, sets out the kinds of things that a judge can do when there's a garnishment dispute in the provincial court, and there's a long list of things which include, in effect, staying the order, suspending it, ordering payments to stop and build up in court. All the options are there. And I would say, yes, there certainly should be a right of the debtor to move to stay enforcement pending a variation.
Now, Paul, Section 11.5 of the Act provides that the debtor shall be presumed to have the ability to pay the arrears and to make subsequent payments under the order unless the contrary is shown. How would a debtor rebut that presumption?
Well, I would think the test is a balance of probabilities, and you would bring in all the usual evidence about lack of employment, pay stubs, tax returns showing no income, unemployment insurance stubs, and all of the usual income data and all of the documentary evidence corroborating the expenses to show that there was no ability to pay. The more interesting question, I think, is whether there is any other defense available other than inability to pay, because 11.5 contains the presumption of ability to pay. 11.6 goes on to say that the court may, unless it is satisfied that there are no arrears, and here's the important words, or that the debtor is unable for valid reasons to pay the arrears, order that the debtor make payments or imprison the debtor or any of the various remedies. So my rhetorical question is, why didn't the drafters simply say that the court may make these orders unless it finds inability to pay? Rather, the words are, unless it is satisfied that the debtor is unable for valid reasons to pay. And the issue then is, are things such as a denial of access a valid reason for not paying a support order. It may be that the wording of subsection 6 opens up a whole new area of defenses for a debtor, and it may not be restricted only to financial inability to pay. Now, Tom mentioned to me the other day that there is one case where one provincial court judge, I believe, has found that the wording unable for valid reasons to pay is restricted to financial reasons. But it's certainly an argument there that even if the presumption is not rebutted, then one could still argue that there are other valid reasons for not paying. And if that's the case, it would open up an entire new area of defenses.
Paul, what if the court finds that the debtor is unable for valid reasons to pay? Can the court do anything further at that point?
Well, again, I hope, it seems to be a case of poor drafting. I hope the drafter isn't here today, but it's not what...
He walked out if you...
Good. It's not what was intended, but it seems that if the court is satisfied that that the debtor is unable for valid reasons to pay, then the court cannot order any of the remedies set out in subsection 6, which certainly doesn't appear to be the intention, because some of those remedies are to provide particulars of any future change of address or employment, or to report periodically to the court. So it seems to encompass the situation where they're worried about, they haven't found an ability to pay presently, but they want the debtor to keep you posted, so to speak. But the wording of the section does not seem to permit that.
Judge Nasmith, what about once an enforcement order is made, can that enforcement order be varied?
I think so.
That's actually, it's section 11.7 of the Act.
Yeah.
Provides that the court that made the enforcement order may vary that order if there's a material change in the debtor's circumstances.
Mm-hmm.
Now, if we look at section 11.6c, which provides that the court may order that the debtor comply with the order to the extent of his or her ability to pay, Judge Nasmith, does that mean that the court can reduce an order, in effect varying it?
I don't think that would be the likely interpretation. And I had a situation like that, as you know. And my case is referred to in the materials. It was a very brief matter. And one of my colleagues at 311 Jarvis Street had assessed support in a case just a few days or weeks before there was an enforcement proceeding. And in the enforcement proceeding, counsel for the debtor, in effect, under that section, wanted to have the issue of quantum retried. And my reaction was, there's something wrong here. I mean, this is an order fresh off the press from my colleague down the hall, and now you want me to hear all the evidence about quantum again. He wants to call evidence about his ability to pay. And I said, surely what you're really doing is appealing here. And the ultimate ruling in the case was that I did not make a finding that he was unable for valid reasons to pay. And I made some comments about the fact that it was really a disguised appeal and that the proper remedy was appeal. He was really saying that the other judge had erred in making the assessment. And I found out today that the case was appealed. And I found out today the result was that the council got together and settled the matter on an appeal, and they set aside my enforcement order, which I forget what it was, but I ordered arrears to be paid under certain terms and on certain conditions. And they, on consent, agreed to discharge my enforcement order, but they retained the original amount of the periodic support that the original judge had assessed.
That's right.
You told me that.
Yes, and that's correct. I think your original order was that there was an order for $450 a month that would stand, and that if the debtor didn't make the payment within 7 days after a certain date, there would be incarceration. And there was an appeal from that order, and the council agreed that they would not proceed with the appeal on condition that the debtor would continue to comply with the order. The arrears would be suspended only until the debtor failed to make a payment, ongoing payment. One payment.
At the regular amount of $450.
That's right. And that once the debtor failed to make that payment within 10 days of the date on which the payment was expected, then all the arrears would become due at that point. Okay. Paul, is there an appeal from an enforcement order?
Well, the Act isn't as draconian as we might think, because the Courts of Justice Act has now been amended to provide for an appeal to the district court for so long as the district court remains with us. So yes, there is a right of appeal.
Okay. And Tom, an enforcement order made under Section 11.6 of the Act, what is its status? Is it a support order within the definition of Section 1?
I think I'm going to mention the word appeal again. Judge Nasmith referred to Dissum and Maxwell. It dealt with a number of issues, and it's really the first case, and to this point, the only case that's really looked at the Act in any depth. And the conclusion of His Honor Judge Bean in that particular decision was that an enforcement order was not a support order as defined under SCOE, and as a result, it could not be enforced pursuant to provisions of SCOE. As I indicated, the decision is under appeal. Appeals to be heard later on in November, at which time we should get a little better indication of just what the district court feels about that particular position.
Okay. We actually have come to the end of our panel questions, or I think we should have come to the end at this point. There was some time allotted for questions, and I think that the panel is going to remain at the front here. We do have all of the people who spoke this afternoon available as well. So maybe we could take the next 15 or 20 minutes, and if there are any questions, maybe you could direct them to me, and then we can, or direct them to whoever you wish, and we'll proceed that way. Are there any questions? Maybe we can start over here. Okay, maybe I should just repeat that. That's Cheryl Rogers, and I think that I should direct the question to you, Tom, and it relates to what happens if an order comes from a reciprocating state. If it goes to a reciprocating state, what would the director do in that situation?
One of the nice things that is happening, certainly in Canada and to a large extent in the U.S., is that we are getting more in the way of automatic enforcement programs in operation in those jurisdictions. Certainly in Canada, we have Alberta as a good example. As far as monitoring, certainly the director's office doesn't forget about the fact that the order has gone out to that jurisdiction. The difficulty is that when these programs exist in the other jurisdiction, they have similar restrictions, obviously, as to how that order is going to be enforced. It has to go through the appropriate procedures in that jurisdiction, and they then control, if there is an enforcement service, what takes place at that end. We, as the director's office, do not go out and follow our own procedures in that other jurisdiction. We rely upon that jurisdiction in the same way that reciprocal enforcement has operated to this point. But we do not certainly lose track of that case once it has gone.
Abby Bushby?
My questions are about Section 15 priority. I wonder what position the director took in speak with the sheriff when he interpreted the feedback. What constitutes the director? For example, a tax debt. Where do you rank priority?
Well, the Creditors Relief Act binds the Crown. So I think the position that would have to be taken is, if that's the case, and if you can style it, as you say, properly as a judgment debt, then in fact the priority would apply. The issue has not as yet come up. I think it's fair to say we anticipate seeing the issue arise, and I can only offer you the fact that, A, the Crown is bound under the Creditors Relief Act, and would presumably certainly be bound by the priority, and secondly, can that be styled properly as a judgment debt?
Are you asking whether he would excuse me, but
No,
I
go
just
ahead,
thought
Jim.
that she was asking whether he would be prepared to participate in a priorities hearing of that nature.
Yes, that's the second part of my question.
I don't speak certainly for the sheriff as to what the sheriff will do. Their obligation arises under the Creditors Relief Act. All I can say is that the sheriff's offices are aware of the existence of the priority, and if they chose to address the issue, which I think they would have to, that they would have to, in fact, have a hearing for purposes of that determination.
Would you
And-
directly representation?
At that time, in that situation, I would certainly think so.
Yes?
Well, we have the reciprocating state question. Suppose it's a reciprocating state that doesn't have any automatic enforcement procedure. They will automatically register the order, if you will, and then they'll enforce it according to their laws. Would your office, hire counsel in that reciprocating state to follow up that enforcement procedure? We'll go that far.
With respect to the reciprocating jurisdictions, certainly as far as Canada is concerned, all of them will do some level of enforcement without having to hire your own counsel.
Well, I'm thinking of one of the states in the United States.
Well, they have EURESA and various other facilities which they're enhancing tremendously as far as the ability to get on to diversion as far as income tax refunds and things like this. So again, they have a system in place. We do pursue it. And in fact, have provided assistance to separate counsel who were involved with a problem with New York State in getting something done for them, and found that the jurisdiction was very, very cooperative. And in fact, like the idea now that Ontario does have an enforcement service, and I think we'll find that the level of cooperation, certainly with the states, will certainly improve when they know that they're going to get a level of service when it comes into Ontario. And it's certainly all part of the reciprocating issue. It's a large issue. It's a difficult thing to deal with. I mean, the simple matter of litigating at long distance as a reality is difficult to deal with.
Are you building up any type of material library in terms of what's available in different jurisdictions? What mechanisms are available?
There are, not only in terms of Canada, but there is a publication put out by an organization in the U.S., which is the National Organization of Support Enforcement Services, which itemizes what every single state in the U.S. does, down to the gory details, names, addresses, the whole deal. So if you wanted to give me a call, I can certainly direct you to that publication. It gives you the full story as far as what they will do.
Yes?
Does any person or public body that should fix the access to information through the corporation?
I think if you look at the Interpretation Act, it includes corporation, because I believe person is defined in such a way as to include corporation.
Any questions over here? Yes?
Talking about the Texas land registration on real property,
Yes.
you seem to indicate you didn't see it being a problem when a property is sold. Of course, I think that's when the worst problems arise is where there are no arrears, spouse refuses to take it off, goes in front of the judge and argues, that was my security, now it's disappearing. How do you see that?
Yeah, that's a good... I'd have to probably defer to Judge Nasmith, because I don't know what he would do. But if there were no arrears, I mean, it seems to me the creditor would have a very difficult argument to hold up a sale of the property if the debtor had a good track record.
I would think that he would argue as a condition, he wants X number of dollars put aside to secure his or her art.
Yeah,
Well, I think that's actually a very good point. I think that if you had a debtor who had a very good track record for making payments on time and so on, and there were no arrears, but this order had been filed just as a precautionary measure, and then the creditor refused to take it off at the time the property was being sold or refinanced or whatever, I would think a debtor could bring a motion to a court and make a pretty good argument for costs on the motion.
Of course, if you want to have sale,
Yeah, but on the other hand, there are all kinds of possibilities if you're acting for a recipient of support who has had many, many problems in the past with a debtor spouse who's never paid, and you've had to take all kinds of enforcement proceedings, and then they want to go and refinance or sell or whatever. I mean, how do you quantify, number one, how do you quantify what's owing, and can you also make that argument, well, look, there's my security. I want to keep it there. I refuse to take it off.
I don't think it's unlike the situation where at the original hearing, on the support application, you could argue under the Family Law Act for security. And the judge at that point is going to look at the possibility or the probability of future default. And the judge has a discretion.
My point is, you've never done that. Now you've gone and encumbered the property, and I can see why you have to come to the registry office.
Yeah.
Well, it's certainly an important issue, and I think that lawyers who are acting for people who are refinancing and whatever, I mean, have to be very concerned about this new act and ensure that the proper steps are taken so that their particular charge gets priority, to ensure that if there is a support order on title and the debtor is refinancing, to make sure that the support order gets deregistered, if you like, before the money is actually advanced. And then after, if it's, say, a mortgage situation, the mortgage goes on, then the support order would go back on title. So I think that lawyers have to be pretty careful. But
I think there's another aspect to that question which has to do with whether or not the court will substitute some other form of security. That was implicit, I think, in his question. And while at first blush it may be a prerequisite to any enforcement proceedings under, say, orders under, say, Section 11, that there be a default, that there be arrears, to trigger the whole thing, I think it's implicit in that question that there may be another way to trigger the remedies under Section 11, because Section 10 subsection 3 says if the court is moved to discharge that security under Section 10, they may make such, on such terms as to security or other matters as the court considers just. And maybe that's an entree into the other remedies. I don't know. It's a good question. And I don't know which court that would be. We now have another constitutional problem there. A motion concerning property.
yes?
Do you think it would be possible to register your order if you wanted to register it on a piece of property owned by the payor and say your spouse or common-law spouse for that property to register?
I would think so. I mean, the section just says a support order may be registered in the proper land registry office against the land of the person, against the land of the person. And I mean, even if you're a joint tenant or a tenant in common, I mean, it's your property. I don't see any reason why not. Have you considered that issue?
Well, you can sell property under a writ of seizure and sale if of a joint tenant, if you have the execution against one of the joint tenants. So I don't see any distinction between that and registering the charge against one of two joint tenants.
Yeah, I certainly think that would be the case. It's just a matter of ownership and what it does in terms of affecting the joint tenancy, whether it severs the joint tenancy and all those other neat issues we have looked at. And it seems to be support for the thought that simply registering it and taking no action does not in fact sever the joint tenancy, but there's certainly nothing to prohibit it from being registered in the first place.
Any other questions? Well, I think that if there are no other questions and nothing else that the panel wants to say, we'll call it a day. And thank you.
Very good. So did I. That was good. You won't take up a lot of time.
Yeah, exactly. We stayed here.